Human Rights Act 1998 and its relation to the European Convention. Introduction. Under the European Union law on the Convention of Human Rights, all the members are required to implement laws into their constitutions that uphold the fundamental rights of all humans. Likewise, laws enacted by the European Court should be adopted into law by member countries and not be seen as mere substantive procedures. Therefore, the members are supposed to implement laws that reflect the acts set by the community and not set up other laws that might be similar to it but undermine the authority of the law. Since the UK is a member of the European Union, it should embrace the human rights articles as dictated by the European Union Convention into its law. The UK in its implementation of the human rights law brought in clauses that contradicted the Convention requirements, thus making the UK Parliament sovereign or superior to the European Community. This resulted in a breach in the European Community laws set by the Convention. Discussion. Human Rights Article 4 was an act passed by the UK Parliament and came into law in 2000. This law was created to embrace the European Convention on Human Rights, which contained various articles on human rights commonly applicable in all European countries. The law aimed to enable the UK to have the capability to take into effect the human rights articles as contained in the European Convention on Human Rights. This act enabled the UK courts to have remedies in cases where the act was breached. Therefore, when the act was breached, there was no need for the UK court to go to the European Courts of Human Rights since there was a provision for that clause in its laws. The act enabled the UK courts to take into consideration the laws of the European Community in any manner that was compatible with the Convention. However, there was a contradiction in the act since it was not possible for UK courts to fully interpret the acts of Parliament and make them compatible with the laid-down Convention. In addition, the UK judges were not allowed to override it or give interpretations that were inconsistent with the acts of Parliament. Hence, in such cases involving the Convention, the judges had no options other than to issue declarations of incompatibility. This declaration did not interfere with the authority of the Act of Parliament, therefore the Human Rights Act sought to show that the UK Parliament was sovereign and superior to the European Court authority. The Human Rights Act applied to all public entities and the bodies exercising public authority over the people, such as the UK courts. Nevertheless, the Act excluded the UK Parliament since it was seen as acting in its legislative capacity and thus should be excluded. Conclusion. The Human Rights Act 1998, which was enacted by Parliament, was meant to bridge the gap between the laws set by the European Convention. Both the laws sought to embrace fundamental human rights across the region. However, as other member states incorporated the Convention into their laws and became enforceable in the courts, the UK brought a different clause into the law that made Parliament be excluded from its application, as they argued that the UK Parliament was sovereign to other laws applicable in the community. However, not all laws passed by the community can directly be adopted by member states, since the member states have different conditions or tendencies towards a particular matter as indicated by their respective constitutions. Nevertheless, the member countries should try and have laws that always reflect the common standing on a subject as other member states in the community. Therefore, the UK is in breach of the Convention on Human Rights and should reverse its laws to embrace a common understanding of the European Convention.